Hear ye. Full appeals state of Illinois now in discussion. The Honorable Thomas C. Cameron, the Honorable Michelle M. Rick, and presiding, the Honorable Michael F. Idola. All persons having business herein draw near, give attention, and they shall be heard. God save the United States, state of Michigan, and this side of the world. Please see.
Morning. Okay, that's passable, I guess. I won't make you do it again. On behalf of my colleagues, Judges Cameron and Rick, welcome to the Michigan Court of Appeals. This is panel 4 in Detroit. This is day 2 of our case call. Sorry if we started a couple minutes late. You can blame Judge Cameron. He brought cannoli and we were enjoying that back there and lost track of time. So I'll give the lawyers my usual advice or admonitions. We've read your briefs. We have reports from our staff on all the cases. We're familiar with the facts. You don't need to belabor those. Just cut right to the most decisive legal issues and tell us as succinctly as you can why you should prevail in your appeal today. In cases involving minor children or protected individuals, just use initials only for those folks. These proceedings are being recorded and will be uploaded to YouTube in the next 24 hours, so initials only in those cases. I think with that, I can proceed to call our first item of the day, which is item number 17, docket number 370833, City of Grand Rapids versus Department of Civil Rights. We have a request for a remote argument granted for plaintiff appellant, Attorney Fossil, and counsel for the appellee, Ms. Mindgast. Okay, waiting for both attorneys to come into the Zoom room.
I'm having difficulty with Miss Fossil, and now she has disappeared.
Okay.
Bear with me.
Yeah, we'll give it a couple minutes here.
Can you hear me?
I can. Yeah, we can hear you. Can't see you as yet.
Well, you're not missing anything.
Okay. If it's all the same to you, we can proceed without seeing you. Is there anything we need to try or do to? Your camera's turned on, I take it.
No, Your Honor, I'm perfectly happy to proceed if the court is prepared.
I think so. Yeah. Why don't you give us your appearance and you can proceed with your argument.
Thank you. My name is Elizabeth Fossil, and I am representing the City of Grand Rapids. In this matter, we are the appellant, and I want to wish you all a very good morning and to thank you for letting me attend this by Zoom, because I don't know what the weather is like on the east side of the state.
Not great.
But we are a mess over here, so I am grateful that I could do this by Zoom.
Sure.
So to get right to it, as the court knows, the Court of Claims granted the appellee defendant's motion to dismiss on 2 grounds. One, that it had no subject matter jurisdiction, and secondly, that the city failed to state a claim as the statute of limitations found in MCL 605.5805 did not apply to administrative proceedings brought by the MDCR under the Elliott Larson Civil Rights Act. As you know, the city respectfully disagrees with both of these rulings. As a preliminary matter, though, I want to additionally note that if the Court of Claims indeed had no subject matter jurisdiction, then it had no power or authority to rule on the substantive issue in the case at all. Thus, if this court agrees with that the Court of Claims had no subject matter jurisdiction over this matter, it should vacate the Court of Claims ruling with respect to the application of the statute of limitations here. On the point of subject matter jurisdiction, as this court knows, we view this lawsuit invoked the exclusive jurisdiction of the Court of Claims under MCL 600.6419, Section 1, Parent 1. The Court of Claims, however, instead focused on MCL 600.6419, Parent 5, in order to suggest that the city the city's original action was either an appeal in disguise or an attempt to get around an appeal from an agency decision. And secondly, the court felt that the circuit court had exclusive jurisdiction of any such appeal, and therefore the Court of Claims itself had no subject matter jurisdiction. To get to that conclusion, the court had to ignore the plain language of Section 1 of MCL 600.6491. And to successfully do that, it had to ignore the fact that the allegations in the city's complaint sought, among other things, an elucidation of its rights going forward with the MDCR, and therefore plainly stated a claim for declaratory relief. Clearly, this court is familiar with the provisions that I'm referring to, but the important part about Section 1 is that it confers exclusive jurisdiction on the Court of Claims for, quote, any demand for declaratory relief against the state or any of its departments. Any means every and all and suggests an absence of limits altogether. So if the court pled an action for declaratory judgment, the Court of Claims had subject matter jurisdiction, and it was exclusive subject matter jurisdiction. Again, as this court knows, subject matter jurisdiction is a matter of the allegations in the pleadings themselves, not the ultimate facts. So the only way that the Court of Claims could avoid jurisdiction here was to conclude that we failed to allege a claim for declaratory relief, but we clearly did. Interestingly enough, I don't believe that the appellees here refute that or challenge that in any way. So I'm going to go over that. I'm going to skip going over that in the interest of time. Despite our pleadings and despite Section 1 of the Court of Claims Act, the court seemed to think that the city failed to establish an actual controversy because it said at the hearing, quote, "You're not asking this court to define for you what your rights and duties are going forward. You're asking the Court of Claims to tell them," meaning the MDCR, "what their rights and duties are. Typically, in a declaratory judgment action, you're worried that your activities may run afoul of some statutory obligation," end quote. That's from transcript at page 33. But here the city was asking the court specifically for guidance on the city's future conduct, not only to preserve its legal rights, but also so the city could avoid running afoul of its legal obligations to the MDCR. So, for example, the city has consistently objected to the MDC's orders for production of documents and information in cases that exceeded the 3-year statute of limitation. If the statute of limitations applies, the city is justified in continuing to object to those discovery requests. If the statute of limitations doesn't apply, then it would be futile for the city to object, and it would actually expose the city to show cause actions as it did in the Ayala case, and even to the potential for attorney's fees and costs. So declaratory judgment is necessary to guide the city's future conduct to protect its legal rights if discovery is improper in these old cases, and to avoid running afoul of its legal obligations to respond to the MDCR's discovery orders if those are in fact proper.
So, counsel, why does the statute apply?
Why does
statute of
Section 1?
Statute of limitations.
Why does it apply?
Yeah.
It applies because number one, the statute itself, the statute of limitations itself, its plain language means that it applies. And what the Court of Claims did in this particular case, which I believe is error, it talked about the fact that the statute of limitations only applied to actions, but the word actions in the statute of limitations does not just refer to court actions or alone, because it refers to all actions. Now, the Court of Claims eliminated the word all. It made that word a nullity.
Well, how do you define action?
How do I define action?
Yeah.
Any claim that is going to recover damages for an individual. And that is what the MDCR does when it institutes administrative actions in the forms of charges. That's how it gets to the ability to claim that it can issue an order requiring the respondent to pay damages and attorney's fees and costs, civil fines, and any other relief that the commission thinks is appropriate.
Doesn't the Civil Rights Act contain its own independent statute of limitations? And if so, how do you harmonize the two?
There are two things to say about that. One is the Elliott Larson Civil Rights Act does not contain a statute of limitations on the process of administrative proceedings going to charges. It only has a limitation on the time in which a claimant can come to the department to file a complaint.
Which is similar to how a statute of limitations operates in the normal course in circuit court, isn't it? And the Civil Rights Statute of Limitations, Civil Rights Act statute is far more restrictive in that regard. It's 180 days versus 3 years, correct?
That's correct.
Okay. So why shouldn't that the limitations period established in the Civil Rights Act be the one made to apply rather than the statute that appears in the Revised Judicature Act?
Because that statute only governs the initiation of investigative proceedings by
So
the
there's the
MCOA.
general statute of limitations, right?
The general statute of limitations is a bar on bringing an action for damages.
Mm-hmm. Okay.
You don't get to that action for damages until the MDCR files an administrative proceeding, an administrative action in the form of a charge against a responding party. Up until that part, there is no action that's been undertaken.
Because the legislature chose not to impose one, correct?
Well, it didn't impose one in the Elliott Larson Civil Rights Act for individual claimants either. The statute of limitations for individual claimants who go to court is the 3-year statute of limitations imposed by the RJA.
Right. But there are alternative remedies. You can do either or.
There are alternative remedies, but the problem is that an individual, well, it's really twofold in many respects. First of all, the individual, by choosing one form over another, can avoid the statute of limitations that would otherwise protect the responding party in a judicial proceeding. Simultaneously, if the individual files with the MDCR and the MDCR can bring an action at any time in the future, today, tomorrow, next year, 20 years from now, then that person is also going to lose out on on his or her ability to go to court, because the 3-year statute of limitations on the judicial proceeding will expire. So they're jeopardized as well as the respondent. The respondent is subjected to prolonged threat of litigation, the threat of loss of evidence. And in fact, in one of these cases, one of the claimants, who was a minor child, the claim was brought on her behalf, died during the process. Now, how do you adjudicate that matter in those circumstances? That makes it very difficult. But the point is, if there is no reasonable limitation on the MDCR's right to pursue action, an administrative action in the form of charges, then a respondent is forever at risk in that particular instance. That makes no sense when a claimant would not be able to do the same thing in the judicial court. And the processes are so similar. You know, with an ALJ, what you're going to find is you have an ability for the MDCR to issue discovery requests and requests to produce and even depose people and order the production of documents, which is all part of a judicial proceeding. It functions in a quasi-judicial fashion. So the fact that a statute of limitations does not exist on the MDCR's unbridled ability to bring an administrative action makes no sense. This is particularly true when there is no clear and unmistakable language in the statute that confers that kind of power on the MDCR.
Ms. Fossil, I think we understand your argument quite well. It was very well and thoroughly briefed. Is there anything else, and you will have time for rebuttal. Anything else you feel compelled to let us know at this point in time?
Yeah, there is one more thing, and I know I briefed it, but I do want to bring it to the court's attention again. And that is the Court of Claims had initially said, I don't think there's any legal basis for us to impose the statute of limitations on the MDCR under these circumstances. We had brought up MCL 600.58213, which states that the periods of limitation for personal actions apply equally to personal actions brought in the name of the people of the state, in the name of any officer of the state, or otherwise for the benefit of this state. The MDCR, when it is enforcing civil rights and filing an action for damages on behalf of an individual, is doing two things. It's acting for the benefit of the state because it's discharging its constitutional mandate to enforce and protect civil rights, but it is also acting on behalf of the individual simultaneously. Therefore, we believe that MCL 600.58213 applies and provides the legal basis for the RJA statute of limitation to be imposed.
Okay, thank you. Any questions for Ms. Fossil? Yes.
I do have one. And Ms. Fossil, thank you for that argument. And all parties have done a terrific job with briefing. I'm more curious. This is such a novel argument. Wondering if there are any examples of success in other jurisdictions that you can point us to. Have similar challenges been raised in
Yes.
other courts?
Yes, in several courts. I believe I briefed a Kentucky case and a Massachusetts case, which both applied the statute of limitations in an administrative context. One did it directly with their state statute of limitations, and one applied it by analogy. And of course, I can't think of, but I can probably look and see.
I can look up your brief, but I'm curious. So you've identified Kentucky and Massachusetts. Either of those involve claims of civil rights violations? I think
No,
when
what
you
they, no,
indicate-
no, I'm
Yeah.
sorry, Erna, I didn't mean to interrupt you.
That's okay. Go ahead.
No, it's not in the civil rights context. They were in other administrative contexts.
Okay, thank you.
Okay. I think we don't have any further questions for you, so you'll have time for rebuttal. Ms. Mindgast?
Good morning, Your Honors. Assistant Attorney General Heather Mindgast on behalf of the Department of Civil Rights and the Michigan Civil Rights Commission. From our perspective, the issues before the court are pretty straightforward, and it does certainly appear that the panel has a good grasp of the issues. So I'm happy to rely principally on our briefing, but briefly, first on the jurisdictional question. I mean, the Court of Claims did not err in this case in holding that the city could and must exhaust the statute of limitations question through the administrative process. It's very clear that this is a question that can be prosecuted through the administrative process itself. The city had it preserved and teed up in the cases that went to a charge. It currently remains teed up in the Ayala case, which is the last sort of untimely complaint at issue, or before the commission and the department, which of course, unfortunately, that case has been stayed and held in abeyance pending the resolution of this case. So this question is teed up. It can be prosecuted through the administrative process. And sort of the only thing I've heard sort of in response from in their briefing and argument is like, well, we don't know if this will happen and it's unclear when it will happen. So concerns about delay, the burden of continuing through an administrative process does not, render a remedy inadequate. So they have an administrative remedy here. Second, and sort of alternatively, the court properly held that the statute of limitations applicable to ELCRA litigation does not apply to administrative proceedings before the department and the commission. And simply the plain text of the RJA, the statutes that they're talking about relying on here, simply do not support the city's strained interpretation of the phrase all actions. So the court can and should affirm on either of these grounds. So that said, I'm happy to answer questions. I'm happy to go on and do a short spiel or.
No, I think we get it. This may be an unfair question. you can't answer it or don't want to, I guess I'd understand, but what's taking so long?
What's taking so long? Well, in hindsight, we probably could have put more information on that in the record, but suffice it to say, and I think that the Auditor General's audit may be in the appendix somewhere. Frankly, it's an underfunded department that got way behind. There's only so many investigators to investigate thousands of complaints. They got behind for a number of years. The pandemic happened. All of this coalesced into a pretty big backlog of cases. What's also unique about this situation with Grand Rapids is that there were dozens of complaints against the department that were in the administrative pipeline. And a significant effort was made by the department to sort of conciliate those en masse, which didn't work. So when conciliation failed, each of those complaints then needed to continue through the investigation into a dismissal or charging type phase. So fortunately, in the last couple of years, we've had a couple good budget cycles. The department has been able to hire a significant number of investigators. They're working very hard. And my understanding is that they are caught up. And relevant here, the only purported untimely complaint left is the Ayala case, which is stayed, pending the outcome of this case. There was one last sort of purported untimely complaint pending against the city and the Department of Police in Grand Rapids. I am aware that there are several, at least a dozen, potentially new complaints in the pipeline against the city and its department, its police department, that are certainly not untimely at the moment and are proceeding along the investigative path. So the department's made considerable efforts to catch up. With respect to Grand Rapids, there is one complaint outstanding, and that is the one that's stayed right now, pending the outcome of this case.
Okay, thank you. Any other questions for Ms. Meingast? Okay. Ms. Fossil, any rebuttal?
Just two quick points, I think, Your Honor. First of all, according to my records, there are actually still 6 pending cases, one of which goes back to 2018. I'm happy to hear the department is trying to catch up, but they are still out there. As far as the Ayala case, it is not teed up for a statute of limitations administrative hearing. That case is in circuit court on the department's a motion to compel discovery. This is one of the ones where we had objected. The case was over 3 years old, and so we objected to further discovery in that particular matter. The other point I want to make is that on the exhaustion of remedies, I find this very interesting. Obviously, with the 3 cases that were withdrawn, there's nothing to appeal. There's no exhaustion issue in those. With the remaining cases, there is no administrative hearing, much less any final order in sight for any of these. And given the department's view that they don't have to bring these cases for administrative proceedings until they want to, or if they ever want to, that argument is a little bit unpersuasive from my standpoint. With that, I will rest on the rest of my briefs.
Okay, thank you very much. We appreciate your arguments. It was indeed well briefed and argued by both sides. Ms. Meingast, good to see you again. It's been quite some time. And Ms. Fossil, appreciate your appearance. Sorry we didn't get to see your face today, but your argument was effective nonetheless. So thank you. The case is submitted.
Thank you.
Thank you. Okay, that takes us to item 18, docket number 371725. Michelle Jean Cycle versus Joseph Christopher Cycle. And attorney, I always struggle with this name. I'll just say Appellee's counsel is arguing remotely. Defendant appellant is here in the courtroom. So there he is. All right, counsel for Appellee is now present. So if you wish to step up to the podium, you may proceed.
Thank you, Your Honors. Good morning, Your Honors, and may it please the court. My name is Thomas Benamou. I represent the defendant appellant in this matter. Before I get started, can I just confirm I can have a few minutes for rebuttal?
Sure.
Thank you. Your Honor, we are asking that this court reverse the trial court and hold that the parties are equally responsible for their 2023 joint income tax liability, which is a tax return that they were filed during the marriage. Or a tax return for a tax year during their marriage. I understand that you have all read everything, and so I appreciate that. So I will be as succinct as I can. And really, the trial court should be reversed for 3 reasons. The first is Section 33 of the parties' agreement is the only section of their agreement that applies. It is the only section that applies to the parties' 2023 personal income tax returns. And it states in no uncertain terms that the parties shall file joint personal income tax returns for 2023, and they shall equally divide any refunds and conversely equally pay any income tax liability.
That seems quite specific.
It is. It is specific. It is not subject to any other portion of the agreement, and full stop. The parties agree, I believe, based on the briefing that was submitted, that the contract is unambiguous. And as this panel well knows, when you're interpreting an unambiguous contract, you look to the plain and unambiguous meaning of the words in the contract. And those are the words. That, in our view, is the end of the inquiry. Nonetheless, the trial court and appellee rely on 2 other sections of the agreement that have nothing to do with the parties' personal income tax liability for 2023 or any of other tax year during which the parties were married. Section 22 applies to liabilities associated with the business. A party's 2023 personal income tax liability is a personal liability. It is not a liability associated with the business. That section would apply, for example, if last year or even this year or even next year, Mr. Cycle was sued to be personally liable on a debt for the company, for example. I'm just making something up. But in that case, yes, he would be solely responsible for it, and he would indemnify the plaintiff, the appellee. Section 31 applies to the tax consequences of the assets that are awarded to the parties as part of the divorce. The parties did not sign their agreement until 2024, after the 2023 tax year. The parties did not have any assets awarded to them until the judgment of divorce was entered. So Section 31 applies to future taxes. So if he incurs a capital gain or he receives income from these businesses moving forward, she's not responsible for any of them, and he is. But during the parties' marriage, the parties were equally responsible for their tax liability, and the parties expressly contracted for what they would do with their 2023 income tax liability. Finally, Your Honors, the interpretation that the trial court put forth results in basically the parties rewriting all of their taxes for all of the tax years during which they were married based on the assets that are awarded to them as part of their divorce moving forward. What that would require is that we recast and rewrite their joint tax returns, determine based on the assets awarded to them after the judgment of divorce, what the tax liability was. And because we can't just do this for 2023, because if that interpretation is the interpretation of this contract, we have to do it for all of the tax years. Octane and Targaryen, which are the 2 business interests at issue, operated at a loss for many parts of the marriage. It resulted in a reduced tax liability to both parties during the marriage. If we do that, then it's not what the parties intended. It's it's an absurd result. But if we do that, the appellee's tax liability is actually going to go up significantly because she can't get the benefit of those tax write-offs of reporting the losses to reduce the taxable income. So, in sum, this is a contract interpretation issue. I realize it's not the sexiest issue before this panel, but we are simply trying to enforce the contract that the parties entered into, pursuant to its plain and unambiguous meaning, and to just briefly address the response, and I appreciate that I will have an opportunity for rebuttal. The extrinsic evidence that they're trying to put forth here has nothing to do with the issue before the court, because we all agree that it's an unambiguous contract. To be clear, wife did get the benefit of this during the marriage, both in reduced tax liability, both in debt and in debt forgiveness, and also in cash in the bank accounts that were ultimately divided. But even if she didn't, she did. But even if she didn't, it doesn't matter, because the parties reached an agreement after extensive litigation, and the agreement is clear. And so for these reasons, we ask that the Court of Appeals reverse the trial court. Thank you.
Any questions from council? All right. You do have time for rebuttal.
Appreciate it.
Counsel, if you could give us your appearance, you may proceed.
Sorry,
We're
I
not hearing
unmute
you.
myself. Yeah, Nick
Okay.
Wiltshire, I, on behalf of the FLE plaintiff, Michelle Cycle. I'll be short, Your Honor, because it's all in my brief. The law is pretty clear. The contract has to be read as a whole. The law is also clear that you must adopt interpretations that are just and reasonable regarding the whole contract. Essentially, they can't have it both ways. He can't receive $130,000 for the sale of these companies, then expect my client to pay the taxes. One of the things that we put in the brief and is in the record below, he didn't even reveal this income to the front of the court when we were figuring out child support. So one of the things that I write in my brief as a conclusion, because it's pretty simple, is it's fine. If he wants to give my client $65,000 of that $130,000, we're happy to pay her share of the $13,000 in tax, but he can't have it both ways. He got arrested for domestic violence. He then goes about and sells these interests in these companies back to his father. And then we don't even get the tax return he will provide it, because one of the things that's in the agreement is that the parties get to review the tax returns. He wouldn't provide it. We got it from the accountant. And then we saw that he had liquidated these liabilities. We had agreed that these two companies, he would get them, and then he would get all liabilities associated with those companies. They argue that this relates to future and prospective liabilities. Those are words that could have been used, but were not used. So our position is that he's responsible because he received this entire benefit, he liquidated this, that he's also responsible for the taxes associated with it. And with that, I'm done, unless your honors, the court has questions for me. The rest of it's in my briefing.
I don't have any. Any
Thank you.
rebuttal, Mr. Benjamin?
Just briefly, Your Honor.
Sure.
Thank you.
And by the way, may I assume that's your client sitting with you at council
It is, yes,
table?
I apologize.
Here in the Court of Appeals, we don't allow that. So you don't have to move. Just stay right where you are. It's fine. But I should have said something at the outset.
Oh, I
But
apologize.
lawyers only cross the bar here. So-
Understood, understood.
Okay.
Apologize
Go
for
ahead
that.
with your rebuttal.
Just two quick things, Your Honor. I'm not going to restate anything I've already said. What I will say is I agree that the whole agreement needs to be read as a whole, and the interpretation that we have put forth does exactly that. The agreement the parties knew how to write in when certain provisions were subject to other provisions of the contract. For example, section 21.b of the agreement says it's subject to section 21.c. Section 23A says it's subject to section 17. Section 24C2 says it's subject to 13. Section 33 about the parties' 2023 personal income tax liability. No limitations, no anything. It is abundantly clear. And so with that, Your Honors, I appreciate your time this morning.
Thank you very much. Appreciate your arguments and for your appearance here. Thank you, Mr. Lulgaraj, if I pronounce that right.
That's great, Your Honor.
Beautiful. All right. Thank you. I took a big risk there. All right.
Thank you.
Appreciate your arguments. The case is submitted. Thank you.
Thank you. I wish everybody a happy holiday season.
Same.
It was good seeing you again, Tom.
Same to you.
On Zoom. Take care.
All right.
Thank you, Judge.
Thank you. Item 19, docket number 374187, Claims Management Consultants of Michigan versus Auto Club Insurance Association.
Good morning, Your Honors. May it please the court, Bradley Amperi on behalf of the appellant, Claims Management Consultants of Michigan, who also goes by Care Michigan. Fairly straightforward issue this morning. Here we're dealing with a rate dispute between a medical provider and an insurance company. Medical provider charges the insurance company based upon what they deem as reasonable. They took the deposition of Mr. Murray, who is the owner of Care Michigan, who laid out the reasoning for why he set his rates. The insurance company then did an independent assessment of that rate and paid what they believed was reasonable. The provider then challenged that by filing suit in circuit court. So therefore, it's left to the trier of fact. And that can't be more clear in the cases that were cited by the appellant, that being the AOPP versus Auto Club Insurance Association, as well as Bronson Methodist Hospital versus Auto Owners Insurance Company. They simply state that this is a question of fact left for the jury. Now, what the trial court did is the trial court has simply stepped in and said, well, the evidence that was presented by Mr. Murray was simply not enough in order to establish the reasonableness of the charge. Therefore, we're dismissing the case, which is simply improper based upon those two cases. And more importantly, the recently decided decision of Hall versus Citizens, which was decided by this honorable court in January of 2025. Now, in that case, it dealt with a similar situation where you had a medical provider charging $110 for nursing care. Now, the court or the trial court granted summary disposition in favor of that company based upon that $110 rate because the insurance company previously paid that rate. And what this honorable court did is they reversed that decision of the trial court, stating that although that is true, and that's an argument that the insurance or that the provider can make to the jury, it's a question of fact of whether that rate is reasonable. And that same principle should apply here. Now, the defense has a 2019 market survey to substantiate why they're paying the $28 per hour. They should simply submit that to the jury based upon Mr. Murray's testimony. You have the factual 2019, which was obviously well before my client started providing the attendant care, that 2019 market survey for the reasoning why they are paying the $28 per hour. And therefore, that should have been decided by the jury, whether my client's rate is reasonable, whether the insurance company, what they're paying is reasonable, or whether it's some rate in between.
Counsel, with all due respect, I think that the trial court looked at the fact that your client in his deposition essentially just said, I set a rate that was fair without correlating it to something, either what others may charge or some kind of objective, means. And I know that he did specify various things like, if you show up on time, you get a bonus, etc., things like that. But I mean, I think that's where my difficulty with this case lies is simply by articulating I set a rate that was fair doesn't seem to really give a jury anything to compare.
And if I could follow on that before you answer, the burden in this seems like it might be somewhat contrary to what you just argued. The burden rests with you and your client at this point. So something more than just sort of stating a rate and it is what it is required, it seems to me. So if you could answer
yes and no. And I think you need to look at my client's testimony as well, too, because one of the questions that was asked of him is, does the insurance companies pay your rate? And he said, I'm paid about half the insurance companies, about 50% of the insurance company pays my rate. And that's how I established that it is, in fact, reasonable. Obviously, accepting payment at 100% by other insurance companies establishes that it's reasonable. Now, the second prong to that is if you actually look at the trial court arguments, the prior attendant care company that provided services in this very matter, which was McDuffie Home Care, charged $40 per hour. And that was presented to the trial court, which the trial court simply just overlooked. So you do have a different rate as far as it relates to even, I know you're indicating maybe a market survey performed by my client to determine whether his rate meets one in the marketplace. But as set out in AOPP, that's just one factor to consider. There's multiple other factors, such as the cost of doing business, as far as setting that rate. And why that's important is if you look at this very matter, now the employees that are hired by my client are W-2 employees. And I think that's a big distinction because if you're looking at a rate that's charged in the marketplace, then you have to determine whether the provider is actually hiring that person as an independent contractor because there's different benefits that are allowed based upon a W-2 employee versus an independent contractor. So simply stating that, well, we can look at a rate across the market and that rate should be something that should be relied upon doesn't necessarily get you to the same exact facts that were presented in this case because of that distinction between an employee and an independent contractor. Because if this is let to stand, what it's going to do is going to allow the trial court to kind of really look at and line item audit and second guess and override medical provider charges at any time they believe a rate should have been calculated differently. And that's not what the No Fault Act allows. That's not what AOP set out, and that's not what Bronson envisioned. Essentially, this is the exact same scenario that you had in Bronson. You had my client who set his charge, and he gave his reasoning for the charges, why I will not be labored to the court, because I know it's articulated pretty well within the briefing. You had the insurance company then do a market survey based upon a 2019 market survey, even though the services started in 2022, for the reasoning why they're paying their rate. My client challenged that and filed suit. Now it's left to the trier of fact to determine which rate is reasonable. Therefore, we're asking for a reversal of the summary disposition order and a remand back to the trial court.
Okay, any other questions? Okay, thank
Thank
you.
you.
You have time for rebuttal as well.
Good morning to the panel. Ben Teague on behalf of Auto Club, requesting that this court affirm summary disposition. Just want to emphasize that this was a summary disposition that was almost on the eve of trial. And as far as provider's burden or the responding party's burden, they only had the same deposition transcript from the co-founder of the provider, no other documentary evidence as far as what are the laundry list of things that he laid out, no other documentary evidence laying out how much those are in terms of how he's then calculating his rate.
Counsel, maybe you can help me with something that your brother counsel stated to us. Did Mr. Murray, I believe it is, at deposition testify that half the insurance companies pay this same rate without question? Or is that in the record?
I believe
as
so,
you
Your
know.
Honor.
Okay.
There was a bit of a discussion of that, and there were just in the trial court, it was only deposition excerpts put in by each party responding
Right.
to summary disposition.
Okay.
But again, looking at his deposition testimony, it was a litany of things, but a lot of that was, I don't know how I calculate rate, get profit.
I don't think that necessarily makes it reasonable, just because some insurers might choose to pay it, but be that as it may, I just wanted to know whether he had in fact made that claim in his deposition.
Understood.
And if I can just understand your response then, counsel, because I do recognize we only have partial records of depositions. Was that included in the motion for summary disposition? And is it in the appendix that we should be looking for that?
Standing here, I can't specifically say where that is in the deposition transcript, Your Honor. I do believe that my supplemental appendix might have only had the excerpts that were specifically submitted. But
Okay, well, we'll do
it's
some
hard keeping track
sleuthing.
between full deposition transcript and the excerpt.
Your opposing
Okay.
counsel may know the answer.
Yeah.
Beyond that, otherwise, relying on my brief, requesting that this court affirm, but can answer any other questions that the court may have.
Any questions for counsel? No, none
Thank you.
here. All right, counsel.
Briefly dealing with the 100% payment that was actually part of plaintiff's exhibit number 2, and it's specifically at page 43.
Trial court or in this court? Exhibit 2.
It was in the trial court and this court.
Okay.
So it was presented both to the trial court along with
Exhibit to in the motion.
yeah, correct.
Practice.
And
Okay.
so it's appendix number 2, plaintiff appellant's appendix number
Thank
2.
you.
Okay.
And just briefly, I mean, the fact remains the same. There was evidence presented outside of just Mr. Murray's testimony to the trial court, as far as related to the prior company charging what they did to establish that this rate is reasonable. We're still maintaining that this is a question for the trial of fact. And with that said, I appreciate and I hope everybody has a happy holiday.
Same to you. Thank you for your arguments and your appearance in court here today. We appreciate it very much. And the case is submitted. Okay. Item number 20, docket number 369938, LaDonna White versus Joshua White, and Attorney Bassett is, as usual, appearing via Zoom. And he's the only lawyer endorsed as Mr. White is in pro par. And did not reserve oral argument, I should add. Okay, Mr. Bassett, you can give us your appearance and you may proceed.
Scott Bassett appearing for the appellant LaDonna White. We've alleged multiple errors by the trial court in this case. The most significant one, I think, is the one that we lead off with in the brief, which is even though my client earned a small fraction of what her husband earned, in fact, the last year before the divorce trial, she only made $4,000 a year, while her husband made $123,000 a year. And in spite of that, the trial court decided to divide up the marital debt so that my client assumed 80% of the debt and her husband only 20% of the debt. What that meant is that my client basically although she was allowed to keep the marital home, which made sense since she was raising the two children and her husband had actually no overnight parenting time with the minor children. So the burden basically was all on her, the responsibility of the children. So she got to keep the home, but she also was stuck with the entire mortgage and the entire home equity line of credit. Between those two, it was nearly $2,500 a month for somebody who earns only $4,000 a year. It just wasn't equitable to divide up the debts in that way. It guaranteed that she was going to struggle financially just to be able to stay in the home. And the trial court gave her only 90 days to refinance the home. Now, she was not able to meet that deadline. This is all, of course, post-judgment and not necessarily part of the record, but you should know that she was ultimately successful in refinancing the home and getting her husband's name off of that. But that was not an easy task for her. But the other problem we have here is the lack of spousal support. This was a 17-year marriage, a dramatic, discrepancy in income between the two parties. And the last time my client worked full-time was the 2017-2018 school year, and after which her full-time position with the Detroit Public Schools was eliminated. And the parties jointly decided that she would not work full-time again and would devote herself to the care of the children and to supporting her husband. So that was a joint decision. There are economic consequences that go along with that joint decision, one of which should have been an award of spousal support. This was kind of a strange case in that when the trial court made its ruling, it suggested that there was going to be spousal support, but then it later amended that, I think correctly, because the life insurance proceeds that the husband received after a death in the family were considered to be marital property because the bulk of those premiums were paid during the marriage from marital assets. So the trial court went back and said, okay, this isn't spousal support. We're going to make it property division in installment payments, but then complicated the matter, or actually made it worse for my client, by having it paid out over a more than 10-year period, 125 months, without providing for any interest on those payments, which of course, over a period of time is going to greatly reduce the actual value of that payout to my client. Much of this, I think, goes to the trial court's error in imputing full-time income to my client. The fact that you're able to secure part-time employment, piecemeal employment at $30 an hour is not the equivalent to being able to secure 40-hour-a-week full-time employment at $30 an hour. And unfortunately, that's what the trial court based child support on, was that imputation of income on a full-time basis. There's nothing in the record presented by either party to suggest that my client was able to secure full-time employment at $30 an hour. In fact, I don't think it was even alleged by the defendant in any of his testimony or by any of his witnesses.
What prevented that from happening?
From being able to secure that employment?
Right.
Okay, well, she has two teenagers that she's raising, and they have a lot of demands on their time. They're
A
involved
lot
in
of single mothers work full-time. I can attest to that from personal experience.
They do. But my client's experience is primarily in the education area.
So was my mother's.
But the positions just aren't available the way that they were at one time. I mean, her full-time position was eliminated by the Detroit Public Schools, and there was no opportunity to obtain another full-time position, especially given that, at that time when the parties were married, they made a joint decision that she wouldn't do that she wouldn't accept full-time employment again. So you take a look at this disparity of income. based upon her actual earnings. And this is a case where spousal support should have been awarded. The other primary issue we have is attorney fees. My client testified and presented detailed information about what she owed her attorney, the extent to which she borrowed money from family members to pay her attorney fees in this very long divorce case. It was long for a number of reasons, in part because there was a change in trial court judges partway through the case, and that protracted things quite a bit. But she basically had to pay her attorney fees out of borrowed funds, and the testimony from the defendant husband was that he used marital assets to pay his attorney fees. So there was a significant disparity there in the source of funds to pay attorney fees. And when you look at the income disparity, this is a case where there should have been an award of attorney fees. Now, my client had regularly made requests for attorney fees throughout the case. And when the trial judge made her ruling at the end, she entirely neglected to address the attorney fee issue. No findings were made until my client's trial counsel raised that issue. And the trial judge responded very briefly, without making any findings on any of the attorney fee factors that we're familiar with from case law, that there would be no attorney fees awarded and each party would pay their own attorney fees. That also was error on that basis alone, because there were no findings. The case.
Mr. Bassett, I think we understand your arguments. It's, again, thoroughly briefed. You did your usual outstanding job in that regard. You're unopposed here today. Is there anything else you feel compelled to let us know about this case? Because it appears we don't have very many questions for you, obviously.
Yeah, I don't hear any questions. I would just like to say on a personal matter, it's been an honor to practice in front of this court. This is my last oral argument before heading into retirement. So this is the last time I will see you in this context.
Well, we will miss you very much. You're a well-renowned, and for very good reason, family law attorney, an expert in the field, and this court has benefited from your fine arguments and representation of your clients, your excellent representation of your clients before this court for decades. I would say, and you'll be missed. I feel fortunate. You argued before my panel in November, I believe, and so I feel lucky to have seen you twice in a row here at the very end of your career. So, and I was going to say, what happened to the Mad Men background that we commented on last time? This is the only time I haven't seen that.
Because of your comments, I changed it.
Well, I actually enjoyed it. So,
if I may point
yes,
of privilege,
please.
I just wanted to also acknowledge that Attorney Bassett had received the Lifetime Achievement Award from the Family Law Institute. I was at the Institute, but sorry to miss you. But again, it speaks to the work that you have done for decades on behalf of your clients and in furtherance of family law, which is so very critical. So congratulations.
Yeah, well-deserved award, and I'm glad they recognized you in that way because it's fitting. So
thank you.
Thank you. All right. As I say, we will miss you. I hope we don't be a stranger to us. We hope to see you here in Michigan at some point in the not too distant future, but enjoy your retirement. It's well-deserved.
Thank you.
All right. Thank you so much. The case is submitted. Thank you. Okay. That brings us to item 21, which is consolidated matters, two docket numbers, 370-780 and 372-653. Rhea Thurman versus Windfire Capital LLC. You may proceed.
Good morning, Your Honor. Good morning, Your Honors. Got that one wrong. Kyle Kelly on behalf of the plaintiff appellant in this case. I will be brief, Your Honor.
Sure.
I want to address three things briefly. The first, the trial court in this case, one of the rationales for dismissal was that the trial court believed that the case sounded in premises liability, but plaintiff did not plead premises liability. Now, in reading defendant's brief, it seems we agree that this is a premises case. So to sum up my argument here, I don't think it matters what the count in the complaint was titled. It was titled general negligence. I didn't draft the complaint. I don't know why it was done that way, but the allegations in the actual complaint reflect a claim that sounds in premises liability.
This is a little bit different. We used to fight over this because of the open and obvious
That's-
doctrine, and plaintiffs were trying to avoid premises, and that's all gone out the window.
100%. And now that distinction, I think, is a little bit more of a distinction without a difference. But in this case, the complaint did, it references a parking lot. Paragraph 10 alleges that defendant breached duty by failing to maintain the property. Paragraph 11 will re-enumerate breaches, uses the word premises 4 times. So regardless of what the count is titled, it does make allegations of premises liability. And the Buhalis case, which again, I briefed this, I don't need to rehash it. You look to the substance of the allegations and not the titles. So in this case, to the extent the trial court's ruling was predicated upon this being not pled in premises liability, I think that's clear error, because regardless of the titles, premises liability was pled here. Moving on, Your Honor, the court also dismissed the case because it believed there was an issue with the causation. And this comes down to, and if the court won't indulge me, I'm going to quote, trial court said, "We don't know what caused this lady to fall. Was it loose pavement? Was it gravel? Was it pavement cracks? We simply don't know." With all due respect to the trial court, those are all the same thing. Ms. Thurman testified. She was entirely consistent. She testified that she slipped on loose pavement in the parking lot that gave way. Then she identifies gravel that was loose. She described pavement cracks in the area. Consider what we're talking about here, judges. When pavement cracks and deteriorates, what happens? Pieces of it break off. Those pieces become loose pavement. They become rocks. When though that pavement is further trampled upon and deteriorated further, it becomes gravel. When that gravel accumulates in and around the cracks, it becomes loose. This is the same condition. Ms. Thurman did not put forth competing theories.
I was just going to say, those conditions don't tend to arise overnight, do they? I mean, we all live in Michigan. We know that.
And
these
that's my
things
next
happen
section.
over time, right?
100%, Your Honor, and I will get to that in my next
Okay.
section.
Sorry. I didn't mean
But to
jump
the
the gun.
extent that the trial court believed Ms. Thurman was speculating or inconsistent, she wasn't. She was giving different words to the same condition. Loose gravel, rocks, loose pavement, cracks, they're all the same thing. They all come from the same thing. And the cases cited by the defense, for example, the Smiley case, the plaintiff in that case said it was oil who caused the fall, and then later on said it was a pothole. One of the other cases, Dykus, he speculates that it was a screw, but had no evidence of the screw. Your Honor, here we have photographs. I attached it. I even put labels in it. We have loose pavement in one. We have a rock. We have loose gravel. It's the same thing. So, Your Honor, I don't believe there was any consistency, and I think the causation is whether it was this particular rock or this particular gravel that came from this particular crack. That is a level of specificity that I don't believe is required here. She slipped on debris caused by dilapidated concrete in a parking lot, and she was entirely consistent about that. Finally, to touch on what Judge Godola just said, these are not conditions that arise overnight. These take time. In this particular case, we took the deposition of the owner of the parking lot, Mr. Feuerstein, and he testifies there's no inspection schedule, there's no inspection records, there's no maintenance records. And he also learned that 6 months before plaintiff in this case fell, another employee had fallen on a rock. Trial court, it's been made. The idea that a rock is different from gravel, is different from loose pavement is, again, a distinction without a difference. It's all the same stuff. It's debris. So the owner in this case knows 6 months beforehand, someone slips on a rock and falls. What do? They send a subcontractor to take a look. I'm quoting from the deposition. What is the result of that look? He doesn't recall. Nothing happens. No repairs, no follow-up. So the defense emphasizes that the prior complaint involved a rock, but again, rock, gravel, loose pavement, it's all the same stuff. So, Your Honor, that is the meat of my appeal. There is the secondary issue as to the cost, which I'm not going to get into because, frankly, the decision on the dismissal frankly would resolve the cost issue one way or the other. So, Your Honor, in this case, there was no inconsistency, there was no speculation. She was entirely consistent that she fell on debris, whatever we're going to call that debris, rocks, gravel, whatever, that had obviously been there a long time, at least 6 months, and the owners had known about it. Your Honor, I think this is a question of fact that needs to go back. Thank you.
Any questions for counsel? Okay, you'll have time for a rebuttal.
Good morning, Your Honors. Josephine DiLorenzo on behalf of defendants. I actually don't have anything to add to what's in my brief, but I'm happy to answer any questions that you might have.
I had a question.
Sure.
I've looked at the photos. I don't know if there's anything on the record that relates to this, but it appeared to me in some of the some or maybe even all of the photos that efforts had been made to patch the whatever you want to call them, potholes, for lack of a better term, in the parking lot. Do we know whether or not your client had undertaken efforts to patch the parking lot?
I don't remember anything in the record about that. And the only thing we said about those photographs is it wasn't exactly clear when they were taken. But that's the only thing that I know about the photographs.
Okay.
Anything else?
I think you'd agree with me that the condition of that parking lot didn't arise in an instant. It wasn't, like one morning that damage.
Right. I mean, it
appeared
wasn't
out of
struck by a
nowhere.
meteor.
I'm sorry.
It wasn't struck by a meteor that morning.
Right.
While
Yeah.
she was at work. But yeah, I guess about that, I guess the only thing I would say about maybe those unpublished cases that we relied on, it's also just because there was a condition in the parking lot, they didn't necessarily prove that that's the reason they fell. But again, I'll just rely on how I argued it in my brief.
Okay. Thank you. Any other questions from counsel? Counsel, any rebuttal?
The only thing I'll add is the reason there's nothing in the record about those repairs is because the owner could not remember, did not maintain records, did not have records. He didn't know.
Yeah. Yeah. Which again,
That's all.
difficult to fathom. All right. Thank you very much. We appreciate your appearance here today and your arguments, and the cases are submitted. Thank you. Last case on our 10 a.m. call, item 22, docket number 373061, Ahmed Almashal versus Westfield Insurance Company. Take your time.
Just in case.
Don't get flustered.
No.
All right.
Good morning, Judge Godola, Judge Cameron, Judge Rick. Ron Sanction on behalf of defendants, American Select Insurance Company and Westfield Insurance Company. As I indicated in the brief, the proper carrier in this matter is American Select, which is a sister company of Westfield, but both of them were named as party defendants in this matter. Your Honors, this matter has been thoroughly briefed, both by myself and by opposing counsel. I simply want to hit the highlights. This claim stems from an auto accident that occurred back on July 13th of 2019. The uninsured motorist claim went to trial, and the jury was asked a simple question. Did a hit and run vehicle whose owner and operator cannot be identified hit a vehicle occupied by plaintiff on July 13th, 2019? That was the only theory that was presented by plaintiff at trial. There were no other alternative theories. There were no mystery accidents. There were no meteor strikes, anything like that. This was just the only issue that was presented, and the jury answered no. And we don't need to delve into the reasons why the jury answered that way. There were numerous discrepancies regarding the plaintiff's testimony at trial that were pointed out by trial counsel and attached as an exhibit to our appellate brief. There were discrepancies regarding the color of the other vehicle. There were discrepancies regarding the speed of the other vehicle. There were discrepancies regarding the damage done to plaintiff's vehicle. Lots of credibility issues, and the jury said no. Because the jury necessarily concluded that the accident, the only version of events argued by plaintiff, did not occur, returned the no cause on the uninsured motorist claim. Now, we had previously agreed to put the PIP claim into arbitration, and I want to make it clear that we are not claiming on appeal that the PIP claim should not have been submitted to arbitration. It had to be submitted to arbitration. What we are claiming is that the panel exceeded its authority in this matter by failing to apply the controlling legal principles. In this case, it's collateral estoppel, although we did raise a res judicata argument based on Manat versus State Farm and Rodwan versus Ameriprise, both of which were discussed at some length in our briefs. The Uniform Arbitration Act, MCL 691.17031D, provides that arbitration awards can be vacated under circumstances where the arbitration panel exceeds its legal authority by failing to apply controlling legal principles. And that was also reiterated by the Supreme Court in Detroit Automobile Insurance Exchange, DAIIE versus Gavin case. And that's what happened here, pure and simple. The arbitration panel should have returned a zero arbitration award based on applying controlling legal principles of collateral estoppel based on the jury's determination that, frankly, no accident had occurred. We're asking the court to reverse the decision of Judge Viviano in the Macomb County Circuit Court when she denied our motion to vacate the arbitration award and remand this matter back to the Macomb County Circuit Court with instructions to enter the appropriate order dismissing the plaintiff case or vacating the arbitration award. I'm happy to answer any questions the panel may have. Again, it's been pretty well briefed.
Yes.
So
Any questions from Mr. Sangster? Okay, thank you. You have time for rebuttal.
Just out of curiosity, if the jury would have done the opposite,
yes,
would you have given it preclusive effect as to that issue?
yeah, if the jury had concluded that plaintiff was involved in an accident with a hit and run vehicle, that is a necessary factual predicate for both a uninsured motorist claim and a PIP claim.
No. You just added something. It's not, a PIP claim is not dependent on being struck by a under or a hit and run driver.
You're correct. A PIP claim is dependent on sustaining accidental bodily injury arising out of the ownership operation,
Right.
maintenance use of a motor vehicle as a motor vehicle. And if the jury had answered that question, yes, then the next question would have been, was the other driver negligent? That one is irrelevant on PIP claim. The next question after that would have been, was the plaintiff injured? And if the jury had gotten to question number 3 and said, yes, there was an accident, yes, the other driver was negligent, but plaintiff did not sustain an injury in that accident, then that's another factual predicate for both the PIP claim and the UM claim. We would have considered that, yes, there was an accident, but there was no accidental bodily injury because that's what the jury concluded in connection with the UM claim. I trust that answers the question.
I think so. All right, thank you. You have time for rebuttal.
Great, thank you.
Indicated.
Good morning, Your Honors. Brian White here appearing on behalf of the appellee in this case. And we briefed it and I'll adjust the point really primarily raised is whether or not this panel acted in contravention of law and obviously whether or not they errantly applied the doctrine of collateral estoppel or didn't apply it in this case. I think we have to first start out and look at these kind of claims. They're two different claims. One is a contractual uninsured motorist claim, and one is a PIP claim. And as Your Honor intimated, there's two different standards that apply to each of these claims. And the interesting part about this jury verdict form is the first question differed from your standard jury instruction that you would have in a third-party claim, which is whether the person was involved in a motor vehicle accident. That's not the question that was asked. It was a contractual question to implicate whether or not there's coverage under that policy. And I think that the arbitration panel correctly identified there was 3 propositions in that question, any one of which the negative would require that jury to say no.
That'd be a different case if these questions had been broken out and question 1 had been, was there an accident? But that's not how it was structured, was it?
I agree with you 100%. And I think the Redwan case, which was cited by both of us, but is what's primarily relied upon by the appellant, would be if the jury had found that he wasn't injured, that would have collateral estoppel in this arbitration.
Yeah.
But that wasn't the specific question that was asked.
It was a compound question.
Exactly.
Had different elements in it than
Different elements.
what's at issue in a PIP case, correct?
And I think that's the key fact in this particular case is that they didn't answer the question whether or not there was an accident. And then, of course, goes to the different standard. In a PIP case, it's whether or not there was involvement of a motor vehicle or motor vehicles being used as a motor vehicle in the ownership, I'm getting it mixed up, but it's whether or not the injury arises out of the involvement of a motor vehicle as a motor vehicle.
Right.
And that's not what was answered in this question. And that's not even an issue essential. And the first element of collateral stop is whether or not there's a fact essential to both claims that was litigated or determined by the jury. And in this case, that was not the case. There's a different standard of whether or not there's liability for a no-fault claim.
I think that sums it up pretty well. Is there anything else you need to share?
There's nothing unless your honors has some questions for me. I think everything else is pretty well briefed.
Any additional questions? I don't have any.
Thank
Mr.
you.
Sangster, I've shown my hand, I suppose, but any rebuttal?
Yes. I think we need to put ourselves into the role of the jury, not as lawyers. Now, us lawyers are trained to parse words and parse sentences and parse phrases and twist and manipulate. I hate to use those terms, but that's what we do. This case was not tried in front of a group of 12 or 6 or 8 attorneys. It was tried in front of a group of lay people. And the question that was posed to them was straightforward. It mirrored the only theory that was presented by plaintiff at trial, only theory as to how this alleged accident occurred. And the jury replied no.
Again, the question was compound and involved, multiple elements. And I think you're stuck with that. And I appreciate the argument about put ourselves in the shoes of the jury. The problem here is we don't know on what basis they reached their verdict because there were multiple questions posed to them in the verdict form.
The jury was never presented with evidence that the accident was caused by anything other than a hit and run motor vehicle.
Well, now you're asking us to go beyond, you're asking us to go into the facts that were presented in the court as opposed to restricting ourselves to collateral estoppel and what that jury verdict form said. I don't know. I'm not going to do a deep dive into what was presented in front of the jury.
Yeah, you don't need to. All you need to do is to review the trial transcript on the closing arguments and the discrepancies that were raised and the credibility issues that were cast. And the jury could not have reached any other conclusion based on the evidence presented other than that the accident itself is a necessary factual predicate to both a claim for PIP benefits and UM benefits simply did not occur. That was what the jury answered no to the very simple question, was the plaintiff injured or and I'll get it right here. Was the plaintiff injured? Did a hit and run vehicle whose owner and operator cannot be identified hit a vehicle occupied by a plaintiff? The only theory that was presented was a hit and run vehicle hit another vehicle occupied by a plaintiff. And the jury said, no, that's the pure definition of an accident. There was no other theory that the hit and run vehicle was actually identified. There was no other evidence that the owner and operator of that vehicle was identified. The common sense meaning of this jury question is that simply the accident did not occur as claimed by.
Well, they could have concluded that it wasn't a hit and run. They could have concluded that the plaintiff knew the driver of the other car. I mean, we just don't know, but I don't think we need to belabor it. Anything else for us?
Nope. Other than that, it's been briefed. And again, it's all in the briefing.
Yeah. Appreciate your arguments.
Thank you.
And for your appearance here in court today. The case is submitted. Mr. Sangster, give my best to your partner, Mr. Januszewski. He may have told you he was my law school classmate. So yeah, no, apparently he didn't tell you. So maybe he's forgotten all about me.
I will certainly tell.
Give him my best, please.
Will do. Thank
All
you so
right.
much.
That's the end of our 10 o'clock call. We're going to take about a 5-minute recess and come back for the 11 a.m.
Michigan's now in session.
Okay. Welcome back. For the benefit of those who weren't here at 10 a.m., we have the benefit of your briefs and reports from our staff. You don't need to belabor the facts. Just cut right to the most salient and decisive legal issues and let us know as succinctly as possible why you should prevail today. If we have any cases involving minor children or protected persons, initials only, and I don't think we need to worry about that. So I'll call the first case on our 11 a.m. call, item 23, docket number 367742, Catherine Teets versus Wyandotte Public Schools.
Good morning, Your Honors. It may please the court, Scott Thompson on behalf of T-Mobile. I'm here, obviously, appellant didn't keep the right to argue, so it's just going to be those of us on the appellee side today. I'm here with my local counsel, Jessica Spartoff. The school district and attorney and I have split the time. I'm sure we won't use anywhere close to anything close to it. But,
okay, thank you.
And I'll take your admonition to try to cut to the point, and my hope is to try to address some of the things that I think the other side would have argued to help the court understand our position on those. In this case, the circuit court really cut through the rhetoric and bombast from the plaintiffs to dismiss their claims on 4 grounds, as you know, that it was an untimely appeal that deprived the court of jurisdiction, that plaintiffs lack standing to bring a nuisance per se or a public nuisance claim because they have no special damages. And that ultimately, even if they had standing and if it were timely, that the merits of the city's decision to grant the permit to T-Mobile to install the antennas on the existing structure was proper under MCL 125.3415. And then finally, the circuit court dismissed plaintiff's claim, their second count for private nuisance, which, as the court I'm sure recognized, was based on their concerns about radio frequency emissions. And the circuit court found that was preempted by FCC regulations. I apologize, Federal Communications Commission, FCC. They have not appealed that last point. They have not appealed the dismissal of their private nuisance claim, so we're not going to address that.
Yep.
Let me first get to the issue of the fact that this was a year late collateral attack. The plaintiffs would argue, well, how would we know to appeal because it was never brought to the Zoning Board of Appeals? But it's clear that 2 things. Number one, they had actual notice, as the record's very clear and as the circuit court found. They were given notice by the school district in September of 2022 by the principal, sent a letter to everybody else, the superintendent, sent a letter to all the surrounding people in September. They then undertook a decision to pursue a remedy of trying to get the school district to breach its contract with T-Mobile. Ultimately, in February of 2023, there was even a written letter from the city's engineer giving its rationale for why it granted the permit. We don't have to get into whether that was the final decision, but at a minimum, they could have sought to appeal that. And under the city's code, their first step should have been an appeal to the Zoning Board of Appeals. Under the city's code, somebody can appeal a decision by any officer, including the engineer, the Zoning Board of Appeals. Then under state law, it should have been 30 days to appeal to circuit court. They didn't do that. They continued on their chosen path of seeking remedy through basically political means. So there's really not even an argument that the second half of the problem with their argument, they argue, well, it was never brought to the Zoning Board of Appeals. That's premised on their false assumption that it had to go to the Planning Commission and the Zoning Board. The state in legislature in MCL 125-3415, I apologize, made a decision that certain kinds of wireless installations would not be subject to special use permits and could be granted without going through that kind of process when it's an antenna being installed on an existing structure. And so their argument for why they were timely, we wouldn't have known, presumes a process that the legislature had said didn't apply.
So this wasn't the result of a rogue employee who didn't understand zoning.
No, Your Honor, absolutely not. In fact, it's clear from their complaint, and as the circuit court properly found, the city in 2014 had adopted or recognized through a resolution when another wireless carrier, Verizon, had done a similar thing. They wanted to put antennas on an existing building in a residential area. And in 2014, the city council had adopted a resolution recognizing that at that time, newer statute preempted, for lack of a better word, their regular zoning code that would have required a special use permit for that kind of installation, or
And
actually, I guess would have, I'm sorry.
I'm sorry, I stepped on your toes. Go ahead.
I'm sorry, did you
I
have a
stepped
follow-up?
on your toes. I did have a follow-up
please.
question. I jumped the gun. Is that part of the record?
Yes, it is, Your Honor. The city's resolution, the 2014 resolution, in fact, was in our joint appendix. I'm sorry, not joint appendix. Plaintiffs didn't file a base numbered appendix, so we submitted our own appendix. So there's a T-Mobile appendix, and that was exhibit. Let me see if I can find it real quick. It's T-Mobile appendix. It starts at base page 71.
Thank you.
And there is, so yes, that was in there. And the city's engineer's written decision articulating its reasons, that was also in the plaintiff's complaint at exhibit G. So the court properly found that this was an untimely appeal that followed this court's decision in Zelasco, in the Cone versus Saginaw case, saying the fact that they've used the label of nuisance is not an end around for failure to file a timely appeal. So we think that the court was correct in doing that. Let me move on to, it's not the next logical step, but let me address that the circuit court correctly found that even if they had timely appeal, and even if they had standing, which I'll get to, the plain language of MCL 125-3514 correctly finds that the city was correct to issue the permit to install an antenna on an existing structure. So the plain language of the statute says that a wireless communications equipment is a permitted use of property, not subject to special land use approval or any other approval under this act, if all the following are met. And the very first part of that condition is the wireless equipment will be co-located on an existing wireless communications support structure or in an existing equipment compound. So this turns on what is an quote unquote existing wireless communications support structure. Plaintiffs try to go with sort of plain, we all know what that means, but the issue is the legislature defined that for us and defined a wireless communications support structure as a structure that's designed to support or is capable of supporting wireless equipment. Plaintiffs really can't deal with that. They would ask the court to add in the words "and is currently supporting," but the legislature chose not to include that kind of language. By contrast, in the definition of a equipment compound, they did include language that recognizes that there is communications equipment currently located. The specific language says within which wireless communications equipment is located. So the legislature knew how to differentiate an equipment compound where they wanted it to currently have located wireless equipment versus an existing structure that was capable of supporting it. Plaintiffs argue, well, that plain language would lead to absurd results. First of all, the courts don't look to absurd results when the plain language is unambiguous. And here the language is unambiguous. But what's more is even the quote unquote absurd results they point to simply don't bear out. This statute is at this point, 13 years old. There are no decided cases under it because there's no ambiguity. People are not struggling with this. Their argument, oh, this could lead to wireless on sheds in people's houses, just isn't the case. Not every structure is capable of supporting wireless. Likewise, the plaintiffs point to the legislative analysis. As we pointed to in our brief, and I won't belabor it, those legislative analyses are not official legislative history. The Supreme Court, Michigan Supreme Court has made clear they're due very little, if any, deference. And in fact, in this case, those legislative analyses don't even really support their position. In fact, the legislative analysis, as we pointed out in our brief, ultimately talks about the desire to avoid the installation of new towers. So the idea that putting antennas on an existing 65-foot tall smokestack on a building is exactly, if anything, what the legislative analysis suggests they wanted to do.
May I ask a question that
Sure.
probably really has nothing to do with the legal merits, but your point about people maybe being incentivized to put one of these cell towers or cell structures on the roof of their home or on their shed. It's $1,000 a month that's going to the school district for the privilege of putting this on the smokestack. Is that correct? That was my understanding of the record.
I don't remember the exact amount, but I'll take your word for it.
Okay, all right. I was going to ask whether that's standard. It seemed like you got off cheap to me. I was just sort of surprised that
No, I
it
think they're
was
fairly,
that amount.
I think it's a fairly, again, this is all off the record. I think it's a fairly standard amount.
Yeah, it's not.
Landlords
part of the
get
record.
about
I was just
the
curious.
same amount.
Mhm.
I'm sure that in downtown Manhattan, they probably get more.
Probably a little more. Yeah.
The last thing I wanted to explain on this point is plaintiffs try to say, oh, Michigan was adopting this federal, it's called the Spectrum Act. It's codified at 47 USC 1455. This was an act that was adopted in 2012, shortly before Michigan legislature adopted its thing. There is nothing suggesting, other than the timing, that Michigan intended to adopt the federal act. And in fact, the language is very different. I would even ask, why would they simply copy the federal language? The federal statute provides that a local government cannot deny and must grant modification of a existing, wireless tower or base station. Those are two terms of art under federal communications law, and a tower was defined long before that as a structure that is designed to support wireless antennas. A base station is a broader term that generally covers the equipment, but could also include like a building. The Michigan legislature did not use that terminology. It went with a slightly broader,
Capable of supporting,
capable
rather
of
than
supporting.
designed to support.
Exactly, Your Honor. So the idea that this was a copy of the federal act, putting aside that, number one, it's very different. Number two, what would be the point of copying the federal act if the federal act controls? The plaintiffs point to a Federal Communications Commission decision in 2013 in which the FCC said that pointed to Michigan as one of several other states that had adopted statutes that, quote, where did it go? Legislative efforts to streamline co-locations. This is far from the Federal Communications Commission saying that Michigan has copied the federal statute. If anything, in 2018, the FCC identified Michigan as one of the states that had adopted a more stringent, meaning more open ability to attach. So to summarize, it was very clear that this circuit court correctly held that the plain language of the statute authorized the city, in fact, required the city to grant this permit without special use process, and that the engineer was correct to do that. The final thing I want to address, and again, I don't mean to belabor this, we had argued that they don't have standing. It's very clear that in order to bring a a nuisance claim under 125.3407, which is what they've claimed, only a government official can bring that. A public nuisance can be brought by a citizen, but to do that, they have to have special damages in order to have standing. And the courts have addressed what special damages are. They have to be unique from the general community. And here, overwhelmingly, particularly in their complaint, but also in their brief on appeal, they argue that their special damages are based on their exposure to those radio frequencies that they're worried about. As the circuit court found, as it's overwhelming from the cases we've cited, that kind of claim is preempted. There's no allegation that the T-Mobile antennas won't be operating within the parameters of the Federal Communications Commission's standards regarding radio frequency emissions. And so they cannot have a claim essentially saying otherwise, which is what they're saying. They're saying this is damaging us. It's like, well, you can't make that claim. It's preempted as long as we're consistent with the FCC's rules.
Counsel, because you're unopposed here.
Yeah, I was about to wrap up.
Okay.
Yeah.
And then I have a question that I want to put to both of you. So,
Okay.
why don't you wrap it up here because you're rapidly running.
Sure,
out of time.
I'll wrap up. There were a few points that they raised in their brief that we pointed out were new that they had not raised before, but that's covered in our brief.
Okay. I'm not sure we have jurisdiction to hear this case.
Okay.
As you may be aware, we have a final order rule in Michigan, which provides, in a nutshell, that the first order that resolves all the claims involving all of the parties is the final order, which is appealable of right as opposed to by leave of the court. And we don't have that here because the municipal defendant or defendants, the city, is still in the case in the trial court, as far as I can tell. They weren't dismissed in the trial court. So I don't think we have a final order from the trial court in this case, which might preclude us or could alternatively give us the option of not resolving this case. Whether we have the power to do it or not, that's a different question. So I just wanted to put that before you. If you aren't prepared to address that, I understand.
And before you answer that, just to play off of that, the fact that the trial court referred to the order entered as a final order,
right,
is not what we look to.
Not decisive.
Right. And that would not have been my response. My response would be that by granting T-Mobile's motion to dismiss and finding that the plaintiffs failed to state a claim in both of their counts, both of those counts were directed at the city as well.
Yeah.
So in doing that, it became a final order, candidly, as to all of the defendants. The fact that there was a separate addressing of the issues that counsel for the school district will get to, my point to you is, if the circuit court was correct in dismissing for failure to state a claim, and in doing so address both of their claims, that was as to all defendants. It didn't need, in other words, the city didn't need to file its own motion to dismiss in order for the order dismissing the claims to apply as to all defendants.
Okay. That's a good answer. Quick on your feet. So, any other questions?
No.
Okay. Counsel, and maybe you can start with that since I probably should have posed that right at the outset anyway.
Well, good morning, Honors. David Shiner on behalf of the Appalese Wyandotte Public School District, the Wyandotte Board of Education, and the individual named board members and individual defendants.
Did you move for summary disposition?
We did.
Okay, go ahead.
Yes, and so we're separate from the city of Wyandotte. We're just the district.
Not the individual counsel like DeSena and these other folks.
Pardon?
Go ahead.
You don't represent either the city or the individual defendants, just or do you as to the individuals?
the individual defendants associated with.
With the
board.
school board.
Correct.
With
And
the school district.
I
should say.
can name them all if you.
No.
So there are individual city defendants as
yes.
well as
So
the city. You don't represent those parties.
Correct.
And they're still in the lawsuit, technically speaking, as far as I can tell.
Technically speaking, yes. And to respond to your question,
Yes.
to the extent that there are remaining claims as far as how I think it's 7.206, the subsection that defines a final order.
Right.
It defines a final order as resolving all pending claims and
resolving all claims against all parties.
correct. So it becomes a jurisdictional question as far as whether it can be heard as an appeal of right.
Mhm.
I will say that I don't know any authority that would, I'm trying to think about how to put this, but to essentially convert this into an application and then you have it that way.
That has been done. I'm not a fan of that.
Okay, and I've never seen it
MO,
and I've never been involved in appeal, but
Although I probably signed orders that, that do that in the past, but
okay, well, to the extent that that's an option, I would suggest maybe we go that route and the court does have jurisdiction to dispose of these claims on appeal. But independent of that, just as far as the issues raised on appeal as to my clients, and I can be brief on this, as far as the individual defendants, the trial court granted summary disposition to the individuals based on governmental immunity. And that was under MCL 691, 14072 and 5, a combination of absolute immunity under subsection 5 and just governmental immunity available to state actors under subsection 2. That hasn't been raised as an issue on appeal. And so we would just request that summary disposition be affirmed as to the grant of the summary disposition as to the individuals. As far as the entity defendants, so the district and the board, the principles specific to governmental immunity granted to the board and the district were fairly well briefed or thoroughly briefed in our brief. But the narrow issue really turns on whether the activities or the actions at play here were governmental in nature or fall within the proprietary function exception. And, the governmental function as defined under 691, 1401B being essentially an activity that is expressly or impliedly mandated or authorized by Constitution, statute, local charter, ordinance, or other law. And those are the activities that are at issue here, specifically under MCL 38011A3 and some of the other subsections.
So what makes this something other than a money-making venture for your client?
I would first refer to the question that you asked
Right.
other counsel.
I knew that was going to come back to. It's not much money.
Right. And to answer your question, the lease was for $1,000 a month and then an extra $150 for utilities. But I must say that I don't know necessarily the going rate, but at least from Your Honor's perspective, they came off pretty cheaply. And but in a more broad.
That wasn't the motivation. What was?
Well, as far as promoting the connectivity and the efficiency of of education within the school and the surrounding area benefits as well. But from a broader sense, though, to fall within the proprietary function, that has to be the primary purpose.
Right.
And when we have these other functions or these other reasons at play and when it falls within the governmental function, then whether a profit, to the extent that it is, whether a profit is turned is somewhat just incidental. but it doesn't take it outside of the governmental function.
I think proprietary function also suggests, that term suggests that you're in the business of doing a particular thing, which in this case, I don't quite see. The district is not in the business of hunting around for opportunities to put cell tower equipment on its structures, I don't think.
Not that I'm aware of, and I wouldn't have enough information about, how often this happened to say that this is a one-off, but this is certainly not something that, like you said, they're in the business of shopping out their property, put cell phone towers on every school building. Unless there are any other questions, any others?
No,
Rely
I don't
on
think
my
so.
briefs.
It was well briefed and well argued. We appreciate your arguments. Thanks for appearing here today. And yes, counsel. No, I don't think so. All right, we're all set. Thank you. Case is submitted. Unless, does anyone wish to? All right, I shouldn't have just hauled off and made that call. All right, item 24. Docket number 373796. DeMorris Callaway versus Shalonda Green. Let the lawyers get themselves situated.
Good morning. May it please the court. My name is Sanford Shulman. I represent the defendant appellants. There were two issues raised in this appeal. I'm not going to get into the first issue. I'm really here to focus on the second issue. The first issue is whether the great weight of the evidence supports the bench trial verdict. And I think I adequately addressed that in the statement of facts and the arguments. I wasn't the trial attorney, but I recognize what the testimony was, and I think I articulated that. What I just want to spend the brief amount of time I have here with you is on the second issue, is the issue that I got involved in post verdict, and that is whether the court should have considered an equitable remedy on unjust enrichment when the testimony was basically that this defendant maintains this property for 10 years. The plaintiff abandons it and the defendant pays taxes, insurance, utilities. Plaintiff doesn't even come by at all, cuts the grass, nothing for a decade. And the arguments that we presented in the post verdict was essentially that the court kind of skimmed over this issue. And even the court was baffled by why the plaintiff had no contact with the property for a decade, in considering the first issue, whether there was a title transfer. It would seem logical, you transfer title, you don't have anything to do with the property for a decade. But our arguments post verdict was the equitable issues and why the court couldn't at least weigh the monies, the efforts, the time for insurance, taxes, utilities, and come up with some equitable decision as to whether there should have been some offset for that decade. So I don't want to get into every single detail of what I've written in the documents, but that's essentially the argument that I wanted to focus on this morning.
Okay, any questions for counsel? All right, thank you. You'll have some time for rebuttal.
Good morning, Your Honors. Judge Goodola, Judge Cameron, Judge Rick. Thank you very much for your hearing today on this matter, especially among our very nice snowy day that we've all probably gone through out in the roads.
Okay.
Indeed.
Tell us your name.
My name is David Mammal, and I represent the plaintiff appellee, DeMorris Callaway.
Okay.
Your Honors, I would like to very briefly discuss the fact that what are we dealing with here? It is essentially a case of two deeds on one hand, which was not addressed by brother counsel, and on the other hand, a case involving a failure to procedurally and substantively provide sufficient reason why, after all the trial had occurred and so forth, that this court should overturn Judge Joseph for the decision he made on unjust enrichment. Let me go first to that, and then I'll circle back to the other briefly. With relation, Your Honors, to the unjust enrichment case, there are four delineated reasons why. Any one of these four reasons is sufficient as to why the unjust enrichment should not be considered whatsoever at this point in time, nor should have Judge Joseph considered it after the hearing. One is statute of limitations. There's a 6-year statute of limitations on this matter. It was not raised in that time frame. Two is, even if we were to set that aside and look at the pleadings, it is required to provide in the responsive pleadings or the affirmative defenses the issue of unjust enrichment. It was not done, Your Honors. Three, with relation, and I should also say that this case went on for 18 months. It had a 2-day trial, and nothing was raised whatsoever with relation to unjust enrichment. There was no exhibit list filed by the defendants in this case. There was no provision of anything during the course of discovery in this case. There was nothing whatsoever. Three is with relation to the fact that we have unclean hands. We have a situation where it was determined by the judge, Judge Joseph, that specifically there's no doubt and there's no question in this court's mind that Mr. Calloway's signature was not notarized, and the court is also convinced that Mr. Calloway did not sign that deed, which essentially we're dealing with forgery of some sort or another. Specifically, to go back to that point of forgery, the defendant, Shalonda Green herself, admitted that the last time that they spoke with each other, with the plaintiff, DeMorris Calloway, was in October of 2014. The alleged deed was not signed until November of 2014. So we're sitting here with a situation where we have unclean hands. Somebody who has forged or otherwise obtained the forged signature and then went to the court building where the register of deeds is contained, it's over above Fishbones, let me get that right, and submitted this deed with the intention that she would maintain that property for the rest of however long she wished. That's the third issue. The fourth issue with respect to this is, let's just do the math. During the course of testimony, Shalonda Green admitted that she made $120,000 in rents off of that property, that home that belonged to my clients. There is a total of a little over $93,000 that she's claiming for taxes, that she's claiming for maintenance, whatever else she might be claiming in that context. All documents which, by the way, again, we never saw until the request for unjust enrichment after trial occurred. Let's just go back briefly to talk about the first section here, and that is the fact that we have a case of two deeds, one which is valid, one which is invalid, one which nobody contests, one which was prepared and filed on March 28th of 2013. The defendant herself said that my client, DeMorris Calloway, was the owner of that property at that point in time. Then we have, if we go back to the second deed, the invalid deed, that's November 7th of 2014. That is one which I already mentioned the judge's statement. He is convinced that DeMorris Calloway did not sign that deed, and it was not notarized with Mr. Calloway there either. There are three witnesses. Mr. Calloway, he stated he did not sign it. The notary public herself, who was employed by Comerica Bank, had a very strict policy of anyone who signed a deed in front of her that she notarized must be in the notary logbook. There was no signature by DeMorris Calloway for that time. Furthermore, she stated that she signed it as to Shalonda Green, which she said specifically meant, and she testified, specifically meant that Shalonda Green was the only signature that she notarized. And third, with relation to the independent expert testimony by Eric Spakeen. Eric Spakeen and his extremely impressive resume is detailed in the brief. However, I can tell you that he stated specifically that it was highly probable that that was not DeMorris Calloway's signature. And then he put it into further layperson's terms, and he further stated that it was, the specific language, again, it's slipping my mind at the moment here. He stated that it was virtually certain, he was virtually certain that that was not the signature of DeMorris Calloway. So what do we have here, Your Honors? We have a matter in which an individual has practically criminally taken advantage of my clients. And now after the trial, in which she's found without a question that it was a forgery, it was something that was not my client's signature. It was something that breached the statute of frauds because DeMorse Callaway did not sign it. She quieted a title because there was a valid deed with his ownership over the invalid deed. And she further stated it was a slander of title because it was a dishonest misrepresentation done with malice against DeMorse Callaway. Happy to address any questions.
Any questions?
None.
I don't think so. Thank you.
Thank you, Your Honor.
Any rebuttal, Mr. Schulman?
I just want to note that when the trial court judge issued a decision as to the issue of unjust enrichment, they didn't talk about statute of limitations or fraud or any of that. It just simply said that while the defendants paid the cost of taxes, maintenance, and utilities, defendants also received the rental income from the property during the period of time. I find that interesting that the plaintiff appellee starts to do the math in front of you. They didn't do the math in the trial court. He's doing the math now. He's holding the hearing that we're asking you to do today. He's talking about 100,000 here, 100,000, whatever those numbers were. That's the hearing that we were asking for.
Okay, thank you very much. Appreciate your arguments and your appearance here today. So thank you, and the case is submitted. Same to you as well. Item 25, docket number 370305, Jessica Dodis Schultz versus Shane Schultz. All right, Mr. Gentry.
Good afternoon, Your Honors, and we have made it to afternoon. Kevin Gentry on behalf of the plaintiff appellant. Your Honors, my client lost the credibility contest before the trial court, and I'm not going to ask Your Honors to change any of that. That don't happen. What I am going to say is that defendant won a credibility contest before the trial court. The trial court said what he was saying was true. And what he was saying was true was that he was managing the accounts that were raised here, the 3 accounts, and moving money in and out and making trades. What he said was true, and that was on page 90 of tab 6 in the appellant. What he said was true was prior to rolling them over in 2016 were these funds acquired during the marriage. They were a mix of marriage and premarital. Your Honors, when then Judge Taylor, later Justice Taylor, wrote Reeves and talked about passive, he was talking about a 1/6 interest in a shopping center in Standish in an Oakland County case. It was totally passive. Nobody had anything to do with it. It just sat there and accumulated wealth as real estate got bigger. Here, this is active. This is moving stuff around. The trial court found it was passive and separate. It wasn't passive and separate. And the defendant's own words say that. It was commingled. It was active. It was commingled. And it had marital funds in there, and he even admitted that. We're on clear error, and I don't take a lot of clear errors up here, but the record says one thing, and the trial court's opinion says another, Your Honors. Thank you.
Thank you. Counsel.
Your Honors, good morning. My name is Tim Flynn. I represent the appellee husband in this case, the defendant in the lower court proceedings. This is one of these cases where you have an appellate standard of review that is fairly complex. We're looking at findings of fact that you're going to assess with clear error, and I don't think there's any dispute here that there's any error of the lower court judge in this, but then this court also is tasked with determining the dispositional property award that was made in this case. And this is a standard of review that the Michigan Supreme Court set forth in Sparks, and I think it bears, a little bit of emphasis. I didn't cite this language in my brief, but this is from Sparks. And it says that the appellate court must decide whether the dispositive ruling was fair and equitable in light of the various factual findings that were made. But because, and I'm quoting now, but because we recognize that the dispositional ruling is an exercise of discretion and that appellate courts are often reluctant to reverse such rulings, we hold that the ruling should be affirmed unless the appellate court is left with a firm conviction that the division was inequitable. So even though we're going to try to look at the various findings of fact in this case, the myriad things that went into this 8-day divorce trial, this panel still has to decide, was it fair and equitable in that dispositional ruling?
Well, can we make that determination, counsel, if there isn't a proper classification of the property that was distributed? I mean,
Well-
because the heart of the issue is, was this separate property or was it marital property?
Right. That's what the appellant would have this panel focus on. And what I'm going to posit to this panel is that even if, there's certain things that are not in dispute. My client had some various series of professional jobs where he was amassing retirement assets, and that the record in the trial is clear that he spent a lot of time working and saving as a young man and during this marriage. There's no question that he had built up these accounts both prior to the marriage and during the marriage. These 3 accounts that are at issue. In the Sparks case, this court, or actually it was the Supreme Court that reversed the divorce case. And I think in that case, there was conduct again. Sparks is the case that tells us it's not a spousal support factor case. This is a property factor case. And in that 8th factor, the conduct of the parties in Sparks, the judge up in Muskegon ruled from the bench. I don't know if it was a 45-page opinion, but this case has a 45-page opinion. And to your Honor's point, this judge has, in those 45 pages, has separated out all the different assets. Each of these spouses had retirement assets. So admittedly, husband's assets included premarital and marital portions, components.
And well, then just to follow up on Judge Rick's question, because I'm not sure we're hearing an answer to it.
Well,
did the judge ever
getting
make
to
that determination? Because based on what you just told us happened, it would seem to me that at least a portion of that retirement asset or assets is marital property. Maybe not all of it, but at least some of it. When contributions are being made during the marriage. And what we don't see in the record, I think I can speak for my colleagues on this, is that this trial judge made specific and definite findings of what is separate property and what is marital property. And that has to happen before you get to Sparks. Once you do that, then you apply Sparks, divvy it up fairly and equitably, and away we go.
Your Honor, and my ultimate point here, I'm smelling a remand. And I don't
how to
think-
read the room.
I really don't think we have to get there.
Okay.
Because I would argue, even if the judge got it wrong and lumped in marital property with my client's premarital portions of it.
Yeah.
When you take the entire circumstances of this 8-day trial into account, you can still argue. I know you're saying, Judge Godola, you're saying it's sort of a prophylactic stop. If we don't have the proper characterization, to Judge Rick's point, then you can't get to an ultimate decision of whether it was equitable. I'm saying when you look at her, you got to read the trial, unfortunately. And when you read that 45-page opinion, you see the method to her madness, even if there's not an accurate characterization of marital, premarital versus marital. It's still an equitable property division when you consider all the different fault that the wife had in this case. This is a tax attorney that never made any income. This is a tax attorney that was jailed for domestic violence, that was found to be, having adulterous affairs and so forth.
I think a lot of that is probably properly considered in the equitable division of property. Maybe not all of those things are, but yeah.
See,
So
if you
I'm
read-
just, I feel that the trial judge sort of jumped the gun and went right to the equity and said, well, this looks fair based on all of some of these factors that you just mentioned, along with others. But with
if you're
going through the proper steps before getting there.
I understand, Judge, and I'm sorry, I don't mean
No,
to
you're fine.
preempt your comments. I take them to heart. In this case, though, it's, a remand to ascertain, which segments of my client's retirement assets are premarital versus marital. I don't know that we're ever going to get to the actual dollar values in this because, if you carefully read this transcript, you will see one of the faults that the lower court took into account when she made this assessment was that the wife hid the documents. This is a gentleman, he's an engineer, but when he started saving, it was back when we all used paper. And he kept these documents very organized in a safe. There's testimony to that effect. And then all of a sudden, a month after she files for divorce, the documents are gone. So the best evidence is gone. And that's one of the things I think that this panel can take into account. The best evidence is gone. And the inference that the lower court made was that she took the best evidence out of the safe. So when you remand this case, if that's what happens, we're going to be right back up here with maybe a little bit different testimony about what makes the savings, what components were marital versus premarital. And we're going to be, and then I'm going to be up here arguing in a year and a half from now that the ultimate division of property, that dispositional ruling, was equitable. And under these circumstances, and I'm not going to belabor it, I think you can get there when you read. You do have to read the trial because the credibility of the wife is weaved in throughout every one of those 8 days of trial.
That has nothing to do with whether property is separate or marital, with due respect. And yeah.
Well, do you
If you've
think
looked at the Riedschlager case, the Supreme Court, you got step one is identify, is the property marital or is it separate? Step one.
And
So
you're saying, Judge, that because she got it wrong with lumping all of my client's retirement assets as a separate property, that she got that was a clear error that impacts the ultimate division of property.
Now, I would certainly encourage, you to do your diligence, but Riedschlager says it pretty definitively. And as the former trial judge who inherited the case, who had to go through and utilize trial transcripts from many a hearing,
I
that
prefer
is step one.
I prefer the Wendell Lawrence case that Judge Cameron was on last month, where you also had a Sparks analysis and you had a trial court making determinations of a 60-40 property split. And that case was upheld, her division of her incongruous property assessment there on very similar factors that are at issue here, the factor 8 of Sparks. That ruling was upheld. I think that this ruling should be upheld as well.
Yeah, Riedschlager came from the Supreme Court, so I don't know if.
I'll do that, Judge. Thank you.
Thank you.
Okay, thank you. I think we get it. Mr. Gentry.
Very few points, Your Honor. 8-day trial, $800,000 and change. This is a huge error. We don't know the amount, I'm told, as to how much is premarital and how much is regular marital. Well, that burden is on the party claiming separate property, and under McNamara versus Horner, if they can't do that, the whole thing's in the kitty. We don't know what percentage this was, if this was a 60-40 or whatever, because as Judge Rick pointed out, we don't know what was separate and what was marital because the judge didn't do that. The judge said in her opinion that the only action defendant took during the marriage related to this account was consolidated with the premarital accounts, therefore the appreciation street passive site Reeves. She didn't do the first step of Reeves, and that's a huge problem. And as to the idea that we can jump to discretionary and Sparks, quote, a trial court necessarily abuses its discretion when it makes an error of law under People versus Al-Sharara. And that's what happened here. The trial court made a massive error of law and everything thereafter falls apart like a house of cards. Thank you, Your Honors.
All right, thank you. Appreciate your arguments and your appearance here today. Well argued. And we appreciate it. The case is submitted. And our final item, which will be submitted on the briefs because Attorney Stone is waived and she was the only person or lawyer involved in the case who was endorsed for oral argument. Item 27, docket number 373-464, in re DBH Moore Minor, will be submitted on the briefs. And with that, we are adjourned.